Good morning. Rob Ryder, Monday, December 5th, 2001. We're going to talk about what a bona fide judgment is and looks like. And you can find the reason for this on robcourtatrecord.wordpress.com. Audio and docs found under Michigan Landlord Richard and Witness Tom. And my email is courtatrecord@aol.com. So, what's a bona fide judgment? Let's see what Bouvier's has to say. Judgment in practice is the decision or sentence of the law given by a court of justice or other competent tribunal as the result of proceedings instituted therein for the redress of an injury. This implies that the judgment is not so much the decision of the court as the sentence of law pronounced and decreed by the court under due deliberation and inquiry. So the decision's been made. It's not the decision, it's the sentence after the decision. To be valid, a judicial judgment must be given by competent judge or court at time and place appointed by law in the form it requires. A judgment would be null if a judge had no jurisdiction of the matter. So when you listen to the audio that I talked about earlier, you will hear that an officer of the county called a notice of judgment, which I'll be showing shortly, a bona fide, what were her words? Bona fide judgment of a court, according to the witnesses. And there's 50 plus other definitions for what a judgment is in Bouvier's. So Webster's, bona fide, with good faith, without fraud or deception. And Bouvier's, bona fide, in or with good faith. The law requires all persons in their transactions to act with good faith, and a contract where the parties have not acted bona fide is void at the pleasure of the innocent party. Somebody said this is bona fide, so I guess we meet the criteria. In civil law, these actions are called bona fide, in which the judge has a more unrestrained power of estimating how much one person ought to give or do for another. But what is good faith? Well, in Bouvier's, he doesn't have a definition for good, but he has one for God. From the Saxon God, good, the source of all good, the supreme being. Every man is presumed to believe in God, and he who opposes a witness on the ground of his unbelief is bound to prove it. So if God is good, God is great. Well, good faith must be God faith. So blasphemy against the Almighty by denying his being or providence was an offense punishable at common law by fine and imprisonment or other infamous corporeal punishment. That's what contempt of court is. Contempt of court is only available to a court of record, and that's you, because you're going to be the judge in this on this judgment. So to not follow it is punishable in common law by fine or imprisonment. Faith, probity. Good faith is the very soul of contracts. Again, we were told we had a good faith judgment. Probity, judgment, honesty. A man of probity is one who loves justice and honesty and who dislikes the contrary. It sounds pretty good to have a good faith judgment. And what do Webster's had to say about good? Valid, legally firm, not weak or defective, having strength adequate to support as a good title, good deed, good claim, good faith. Doesn't say that there, but I'm adding it. Valid, sound, not weak, false, or fallacious, as a good argument. So I'm not going to read all these. Webster's 1828 definition of good. These are just some that I pulled out. So I'm just going to slowly go through, and you can stop and read them yourself, or go to the dictionary. I don't want to make this video too long, or it takes too long to upload. A few more. Useful, valuable, having qualities or a tendency to produce a good effect. equal, adequate, competent in the red, to make good, to perform, to fulfill, as to make good one's word or promise. That is, to make it entire or unbroken. To confirm or establish, to prove, to verify, as to make good a charge or accusation. So if you have a bona fide judgment, and as I was talking to a couple brothers on Friday, Hugh and his son Noah, the judge said, well, this is just an opinion, but it's a good faith opinion. Uh, and from what we've seen, that's a pretty powerful thing to have. So I would just go back with that if a judge ever said that. Is this not a good faith opinion? And is there any proof to the contrary? And if there isn't, then it's the law. Good, that contributes to diminish or remove pain or to increase happiness or prosperity, benefit, advantage, opposed to evil or misery. Well, I want to be on the side of good, not on the side of evil. So I like good faith. In faith, of course, to persuade, to draw towards anything, to conciliate, to believe, to obey. Belief, the assent of the mind to the truth of what is declared by another, resting on his authority or veracity. Well, they said it's bona fide judgment, good faith judgment. They have the belief, the assent of the mind to the truth of what is declared by another. So we declared it, they're agreeing. They said it's good faith, bona fide. The assent of the mind to the truth of a proposition advanced by another, belief, or probable evidence of any kind. Again, they're the ones who said it was bona fide judgment. In theology, the assent of the mind or understanding of the truth of what God has revealed. Evangelical, justifying or saving faith, is the assent of the mind to the truth of the divine revelation on the authority of God's testimony. Without faith, it is impossible to please God. And we have a good faith judgment. And then just a few more. With the heart man believeth to righteousness. Faith is an affectionate, practical confidence in the testimony of God. Faith is a firm, cordial belief in the veracity of God and in all declarations of His Word. They said that your document has full faith, bona fide. It has the veracity of God. Who are they to go against God? To go against it, they have to break God's law. And they will not do that. Just tell them what it is. And there's a few more to finish up. So anyways, when you listen to the audio, you'll hear us talking about some documents that I had come up in the past that they had modified to their own use. And that's why I don't send them out as Word documents. I will not send them out as a Word document. I'm going to send them out as a PDF. That's how they're on the website. Or you can just stop the damn video as we go through these and write it down. I feel it's very important that you own all the words on your paper. You're not writing my paper, you're writing your paper. That is your free will act and deed, not mine. I don't care if you use the same words, just make sure you know what they are. So, notice a judgment. Let's start with what gives it its power and why this registered deeds said what she did. And so we're going to look at the certificate of authority, or it could be called many things, but this is what you get after you've had the notary do the acknowledgement on your free will act and deed, which can have many, many titles. But at the bottom you put an acknowledgement certificate, and the notary is going to witness it for you under her seal. And then you want to go get something like this. Now in Michigan, you can get this from the county clerk, because in Michigan, the notaries have a commission from the county, and it says you can go to them to get the certificate of authority. I've done it. The guys you hear talking haven't done it. It happens all the time. Some states you have to go to the Secretary of State. But nevertheless, you must have this testimony. This is the third witness on your common law deed. You're the first. A man is conscious and always before the Creator. He doesn't need to take an oath. The notary and the person that did this are under their oath, and when they're under their seal, which means they are conscious before the Creator for that time. So, there's not a lot of drama. This thing is actually maybe a quarter of a page long, and on mine they taped it to a 8.5 by 11 to run it through the machine. With landlord Rich and Tom, they wouldn't do that. So they had to go back to the county clerk and ask him to put it on an 8.5 by 11. And that was a big problem. But eventually it got worked out. And they did do it. And theirs would say something similar to this, that Kristen Millard, the clerk of said county and clerk of the circuit court, and in Michigan, circuit courts are the court of record, which is, guess what, is a court of record, having a seal, do hereby certify that the person that did my notary work, whose name is subscribed to the certificate or proof of acknowledgement on the annexed instrument, and therein written, was at the time inking such proof of acknowledgement a notary public, in and said county, duly commissioned and qualified, duly authorized to take same. And further, that I am well acquainted with the handwriting of the notary, and verily believe that the signature of the said certificate of proof or acknowledgement is genuine. I further certify that the said instrument is executed and acknowledged according to the laws of the state. In testimony whereof I have hereunto set my hand and affixed the seal of the said court and county of Stanton on the 12th of September. So this is something I put in on the 12th of September. I didn't do the rest of what these gentlemen are talking about. I was on the path trying to figure it out. I didn't know what these papers were, the birth documents, so I tried it a different way. Now, there's a big space over here. It doesn't show up, but there's a seal here from the, excuse me, actually, I'm wrong. Mine is up here in this area. And it says that it's from the circuit court of Montcalm. So it's under the seal of a court of record. It is a court order. So, so that's, this is actually the last thing you get when you do a notice of judgment or anything that is an acknowledgement of your free will act and deed. Knowing what I know now, I don't know if I'd call it a notice of judgment. I'm not really sure what I'd call it. But they do have in the Register of Deeds office a file for judgments. When you read in the Torrens Act, it says to take the owner's certificate of title, which you'll find out is a certificate of live birth as we go on, and an acknowledgement in some places, or it says a deed, and again an acknowledgement is your free will act and deed, so it is a deed, so let's just call it a deed and be done with it. Your deed that you wish to have the land unregistered. And then in my case, I'm adding something to it that says, and I'm also claiming the beneficial interest, just so they know why I'm there. So, nevertheless, as you'll hear in the video, these two documents are going to get split by the Register of Deeds, but she still says what they are. And this is the one she spent some time reading. Now again, this one is written for me. This isn't the one they used. They modified it for themselves. And but he said he just changed the acknowledgement certificate, so we're going to go with this. Notice of judgment. My will in the matter of Robert Allen Rutluski and my land. Notice to master is notice to servant. Notice to servant is notice to master. That's common law. It's not whatever the other one is they use in commerce. I come to know him in an experimental way, that I may arrive at the goal, the out-resurrection from among those who are the dead. That's where I'm trying to get to. Be it known to all men and their persons, I, Robert Allen, given fee simple estate of inheritance from the father, am the registered owner with an indefeasible title to my land, lawful owner of the real property and interest, known as Robert Allen Ritlewski, have appeared, and this public record of judgment is full proof of my appearance and age of majority, having full faith and credit of the government for the people. Now, I put Robert Allen because that's your given name, right? And by hanging your last name on it, you diminish its power. This is a gift from the Creator. He knew your name before your parents did. This all capital letter name here is the name of a landed estate that's been registered with the county at birth. And it's the real property and interest is what it is. The real property is your body, and the interest is the personal property that goes with the landed estate. So further, I'm an immortal living soul created in the image of the Father, here as one of his people, conscious of my trinity of heart, mind, and soul, born a child of God, now living as a man of peace, and tribunal of the court of record of my sovereign nation state, whose judgment is a living man, one of the people, sovereign power of my land, answerable only to the Father. I, as grantee, accept the covenant known as the New Testament, the deeds known as the Constitution of and for the United States of America, Michigan, and other treaties of peace. I accept the promissory oaths of all public officers and vows of clergy to be servants who by fealty and homage to me bear faith in opposition to all men without any saving or exception. And I protect the kings, princes, and people from belligerents. I extend my sovereign immunity to said public officers performing their lawful duties in regards to my business and protection. Now, all that stuff in there have long definitions. If you go look, put the word promissory oath in and go find a Bible dictionary and see what it says. Bear faith in opposition to all men, a saving is a section. That's out of Blackstone's. To protect the kings, princes, and people from belligerents. That's the definition of people in Bouvier's. There's an insurance policy in which the people, small p, are protected by the insurer from belligerents. The definition of people in Bouvier's. So, let it be known to the entire world that I call upon public officers to perform their lawful duties to correct the errors in records that may now indicate that I am lost across the sea, incompetent, infant, or other malady, and that I am any other man's citizen, or that another man speaks to the Father for me. Further, my inheritance and land and tenements from the Father and my ancestors shall no longer be controlled by a guardian or trustee, nor is my land or real property and interest to be considered abandoned. All letters or powers of appointment or attorney over my land or real property and interest are here, now, and after revoked. Further, that my status as a living man, one of the people, sovereign power of my land, in charge of my own affairs, shall be recognized by all nations. No person in any form has status to bring a claim against me. My land or real property and interest, and any such charge or claim currently existing, must be immediately discharged, or the parties bringing such claim or charge are warring against the Constitution, which may be construed as treason. Any writ issued by Robert Allen, tribunal of the court of record, orally or witnessed under his hand and seal, is binding on all officers, courts, corporations, and persons, and a writ is just an order. Any public officer who refuses to execute my lawful orders is in violation of their oath. A copy of this judgment, done under my hand and seal, is to be considered a true copy, and full proof in all civil matters whatsoever. So I was getting away from having to go back to them again and again and again to get certified copies when I was doing this. I'm just going to tell them, if I give you a copy and it's under my seal, then it's the copy. It's a true copy, which we're going to find out are probably not the best words. Oh, I want to go back to this real quick. Sorry. Up here, where Lori Wilson did her thing, it says, I hereby certify that this is a true and correct reproduction of the instrument recorded in the Register of Deeds. It doesn't say it's a copy. It's a true and correct reproduction of the instrument recorded in the Register of Deeds, which I think is different than most things that seals or stamps you would get out of their office. and the second page. Bear with me. So I call upon my coroner. Now the coroner in common law is an ancient office. It's debatable who's first, the sheriff or the coroner, but they're around the same time. The most oldest offices in common law, and the job of the coroner was many, but he was the protector of the king's pleas. Keeper of the king's pleas, the king's orders, and protector of his property. And his other job was to keep an eye on the sheriff. So I call upon my coroner to collect my king's revenue, my inheritance from the father, ancestral line, and the recomps of any debts against their or my estates. All rents, profits, and other revenue shall be immediately made available to me in a form accepted by all nations in the world. All records and registers that apply to Robert Allen or Robert Allen Rulewski and its variations shall be secured, examined, accounted, and corrected as necessary to reflect I, Robert Allen, the proper owner, having appeared competent and the age of majority, a sovereign authority existing outside any corporate or foreign jurisdictions, shall not be detained, harassed, or any of my God-given rights violated. As evidence of my inheritance, I offer, and then these are just my birth documents. I got a certificate of live birth, and it had a file number on it, and a birth number and a file number. So this is like the legal description of the property, received by local registrar September 18th, 1958, and it's now remaining with the clerk of the county of Bay. And then I have another one called a certified copy of record of birth, which is another document. The certificate of live birth is received by the local register within a couple weeks of your birth. I was born September 5th. You can see she got it September 18th. Certified copy record of birth was recorded September 7th, 1958, but I didn't get a copy of it until I was about 5 years old. And on the outside of the envelope that it comes in, it has for the name Robert Allen. Finally, as sovereign power of my nation state, I declare my peaceful intentions towards all other peaceful nation states to strive for my own perfection, help other peaceful nations strive for theirs, and come to the aid of weaker peaceful nations under duress from belligerents. That's your job. If you want to do this and be a sovereign nation state, go read the first chapter of the Law of Nations. You got 3 duties. You're supposed to strive to perfect your perfection, help other peaceful nations strive for theirs, and protect weaker peaceful nation states from belligerents. That's what comes with the status of man. If my participation is required to carry out this lawful judgment, officers as servants to a self-governing man are called upon to speak to me in a common language of the time. They're always working in my best interest. And I told them, that's where you can get a hold of me. You guys need me, right? I put all my stuff out. And this is kind of crazy on here. On a free will act and deed, you're not supposed to have to sign it in front of the person. They're only there to witness that you said you did a free will act and deed, but I wasn't going to argue with the notary. I had already signed it. She wanted me to put, the spelling underneath and then sign it again. Well, that was my suggestion. She said, well, I need to have you witness the signature. Oh, okay, I'll do it again. But your signature is actually your seal. If you go look at a common law deed, such as a warranty deed, you'll find out when you put your signature on that line, it was actually acting as your seal. A lot of them have the word seal in parentheses after the words. And so this is my certificate, acknowledgement certificate, right? This is what the notary is going to be involved in. Real simple. State of Michigan, County of Montcalm. On the 12th day, before me, the subscriber, who's the notary, personally appeared, Robert Allen Rulewski, to me known to be a living man described in, who executed the foregoing instrument and acknowledged before me that he executed the same of his free will act and deed. And all it has is a rubber stamp. There's no seal. That is all she put on it. Right? She's from the county of Montcalm, and it says when her county expires. Well, when I went from this to this, all I told them is that I had a notary from the county. Her name was Jeannie Embargo, do an acknowledgement for me, and I needed a certificate of authority for her. And it's quite funny because the lady behind the desk said, "Well, yeah, we can do that." Um, but then she starts rumbling around in the desk, and she said, "We hardly ever get asked to do this." And to me, that's the most important thing, that we're doing things that haven't been done before. But yes, it can be done, it should be done, or she wouldn't have done it. So it hadn't been done before. So for the brothers out there, Hugh and Noah, um, if they're putting this into their court cases also, um, and again, I don't know if it's written perfectly for anything, but you can read what it says, and as long as you have faith in everything it says, it will be considered by an officer of the county as being a bona fide judgment from a court of record. Okay, so just one last thing. The documents that are going to be discussed on the audio that you listen to. Again, these are mine. These aren't them, but they're from Michigan, so I know they're fairly close to being the same. Let's see if we can get this thing in here. Okay. So this thing is less than a full sheet of paper. It's called a certificate of live birth. There's the birth number I was talking about, and there's the file number. It has an address, this area in here, and I gotta make it bigger so I can read this dang thing. So we'll get bigger now. So you can see in the child's name, it has my all capital letter name in there. And the sex is male. That's important because on another piece of paper, the sex is boy. There must be a difference. There's the father of the child, the mother of the child. All right? So, and then as we go down, we'll just look at the whole thing real quick and then go look at the rest again. Father, mother, and then we get to the informant part, the infamous informant part, where now mother has her maiden name and her last name. Where up here, she just had her maiden name as the mother of the child, just her maiden name. And then here in this lower left-hand corner, which for some reason is off the screen there, and I just have to read it off mine. It says, I hereby certify that I attended the birth of this child who was born alive on the date stated above. Now look at the word child as all lowercase, but up on the top, child's name is in all uppercase. Must be somebody different. And this man says he was born alive. So this is a two-part document. Where it has your mother of child, father of child, it's the union of their estates that produced the estate of my all capital letter name. And as the father is the sovereign of the union, on the documents from the hospital, have your footprints, your weight, and so forth on there. His name is subscribed at the top. And that document is actually the land patent to your body. And we'll take a quick look at those later. Sorry about the phone. Next, this. Somebody with a question. I'll get back to you. But so at the top, this is your mom's as her estate, and your father as his estate, which together created the land for the spirit man being sent down by the Creator, who sent you here with your given name. You're a child of God. Your mom and dad just provided the vessel. So here at the bottom, now again, they got child in lowercase, which to me is always significant when why would it be in uppercase where it says child's name at the top and in lowercase here? Um, and, uh, and she's acting as an informant, which is a witness. Well, the guy who's certifying, the doctor, is also doing it as a witness, and they're both saying that the child was born alive. Now, put the word alive in your statutes for your state. Go to the state statutes where you can search them. You got to have a keyword search somewhere. Put in the word alive. See how many different things come up alive. There's not that many. It's quite interesting, but there are a few. And one that I talked about on the tape is found in the estates of protected individuals. And I went to look for the definition of individual in Bouvier's, and he doesn't have one. So individual isn't a lawful word, apparently. So then I went to Webster's 1828, and it talks about the completeness of the soul. I'll have to go look at that real quick. So now these aren't the document. This document isn't on there, but this is from an audio I did earlier, or a video I did earlier, and it's a copy of what a brother got from the hospital. And it's a two-sided document, and at the top it's got a seal or a picture of the hospital, and it says this certifies that this is where your all capital letter name is, was born to mom and dad in their upper and lower case, right? So that's their real names, and what they're saying here is your all capital letter name is the name of a landed estate that's been created in this hospital, yada yada yada. In witness, so we got a witness here for the director, and I think it had the attending physician on there too, and it has a seal. So this is a common law deed. That's the front of it. Not a lot on there, except on the front it has your name. Now, this is what Blackstone's would call a closed court roll. And it's written as a land patent, but it's only for one person or one man, where in real estate, the land patents are open because that land, which is all the creators, we have no business buying or selling it. Who are we to say we can buy and sell the creators' property? Nevertheless, it's all his. So what they did is they split it all up into pieces, and they gave it away on a grant. That's the land patent. It was given for free to the first man who claimed it. And it's us, we, who afterwards have been buying and selling it. So they did nothing wrong. You're doing it to yourself. Okay. Now we'll look at the other side of this. So on the back side it said family history, and it had the father's full name because he's the sovereign. This is where he's subscribing. And it has his first and middle, had 5 spaces, and had the last. Right? And that's significant. They're splitting the two names from each other. Again, this is from your sovereign father. Your mother's maiden name, first and middle and maiden. But her estate has been given to your father. The sex of the child is boy. Weight at birth. To me, this is the metes and bounds. And your landmarks, your left footprint, your right footprint. And this had a place to put thumbprints on. They were blank. And then at the bottom, this certificate of birth has no legal value. If it becomes necessary to acquire proof of date of birth, a certified copy of official birth registration may be obtained from the health department, city of Tacoma. So this isn't the official one. You can get one. This is, the souvenir copy, and it's missing some stuff. So again, that one wasn't on there. But I wanted to show you to see what the closed court roll looks like. That's the land patent to your body. When you take in the certificate of live birth, which the Register of Deeds called a death certificate. All right, so this form here, go back to this real quick. View, rotate. This form here, certificate of live birth, out of the mouth of an officer of the county said that this is a death certificate. Well, she's correct in that I'm not going to disagree with her. It is. It's killing the legal person. And when these guys went over, they asked, well, what happens to this next? And she told them, well, it goes across the hall. What's across the hall? The equalization department. What's that? It has something to do with money, it sounds like to me. So when they were leaving, they decided to pop in and ask some questions. And one of the questions was, what do you do with a death certificate? And they said, well, we take the owner off the tax rolls. So somebody's getting removed from a tax roll. So this is a death certificate. It's also the writ of an infant. Brother Chris up there in Quebec, he has one from, Chris, I hope it was El Salvador you told me from, brother. I believe it was. It has the initials T dot R dot on it, and when you go to an abbreviation dictionary and follow the little journey you have to get to, you come to see that it's the writ of an infant. And since then, we've been reading about the laws of infants, and I've already put some stuff out on that. I'm not going to go through a lot again. But basically, it's a writ to undo something that's been done. And really, all that's been done is, when you think about it reasonably, how can an infant be made a party to a contract? Well, they got around it by one case in the 1700s where they decided that an infant's deeds could either be void on their face, not valid at all, or voidable, which means it could be voided, but they haven't been, because an infant can't be made a party to a contract. But if it was for the infant's benefit, then it was just voidable. So it would run until it was voided. We've just never voided this contract, but it doesn't mean that it wasn't good for us, because we leased them the fiction. We're the sovereign, and the sovereign's the one who gives out offices, benefices, fees, franchise, and all those incorporeal hereditaments. What I could just call the fiction, basically, we lease them the fiction. And they owe us rent, and it's being held in reserve, and that's what's in all these escrow accounts that are attached to your name. As long as it sits in the escrow account, it's considered reserve. And if it's in somebody's account as a reserve, they can fractionalize off it to run their debt system. When we pull that out, the escrow, then whatever debt it represents has to come out of the system. There's not anything behind it to support it anymore, which means those debt instruments are coming out of some bank. It's a bad day to be a banker. Now, I've never been a wealthy man, but I've made some fairly good money in my life, and I know how much it hurt for me to lose what I thought was adequate for what I wanted. Think about what's going to happen to these people who live their life for that frickin' dollar when they starts coming out of their account. It's the beginning of their Armageddon, and you can help. Okay, so this is the other document that I talked about in that this is the other document I talked about. Let's get it down small enough. I talked about a statute in Michigan, and it's under the Judiciary Act, but it's part of this estates and protected individuals portion of the statutes. And it said in there to certify death or status, and it's just a very short paragraph. I'd go look for it now, but I got too many things open, and the computer might freeze up. But if you listen to the audio, you'll hear the number, and you can go look this up yourself. It said if you brought in a certified copy of a record, or they used another word. That doesn't matter. That it could be used to confirm if somebody was dead or alive. And so, for the brothers that went and did this the other day, this still may come into play, but this was already referenced in the notice of judgment, because I had two things in there. I had the certificate of live birth that I talked about and the certified copy of record of birth. Now, look at this here. Here's my all capital letter name at the top, right? But here, who it's to is Ritlewski, comma, Robert Allen. This is you, right? Now we're not talking uh, um, the fiction anymore. This is you. And it's put into a record in Lieber book and was recorded October 7th, 1958. So I think that what we're looking at here, because it has Stephen Toth doing this as the county clerk. That's one of his positions. But up here where he's putting the seal, he's doing it as the clerk of the circuit court. So the clerk of the circuit court put their seal on it. That's like you putting your seal on it. And then he had two witnesses, himself in another office, and then his deputy clerk. So the grantor, in my opinion, this is like the deed of defeasance, revocation, whatever it is, that they, the grantor, have already signed, sealed, and delivered, because this was given to me. It's in a little envelope. And the grantor now is in a binding contract. Because it's done in common law, the contract never, the deed never goes away. It's just waiting for the proper owner to appear and acknowledge it. The deed's not been acknowledged by the grantee. See, the grantor is up here. I, Stephen Toth, clerk of the county. This is the property, and to me, Robert Allen Ritlewski, and then this is the grantee, me. But I never took this down and acknowledged it. I had it recorded. You can see I've had it recorded up here in the corner. I've had it recorded twice. But I didn't acknowledge it. I just asked them to record the damn thing. Right? And this is interesting. The following is a copy, right? Not a true copy. Not a reproduction of the record, just a copy of the record of birth for. So there's a bunch of stuff missing. SS dot up here, has a definition. This parentheses looking gizmo has a definition. I don't know where to find it. I think it means words or a set of values. But the one that's really interesting on here, you can barely see it. It's over here in the corner. Let me pop it up a little bit. See if that changes it. The word viz, V-I-Z, Vildeset, which is, damn it, I should have had that email pulled up. Oh, I can. Hang on here. We'll look at this real quick if it'll let us. And that'll be the end of this particular video. Hang on. Here's an email I sent out. Sorry, guys. This is what you deal with. I sent this out on the day before I went to jail. I think it said November 2nd. My point is that every mark, word, abbreviation on these documents means something. It's only there for a reason, right? It's on there for a reason, or why would they put it on? Yeah, November. Oh, looks like November 20th. Oh, so no, it was just quite recently. And it talks about the office of the Vildeset. Well, what the hell is an office of the Vildeset? It's something I need to look up yet. I'm glad I came back here. What does that mean? It's an office of the Vildeset. And when you go through it, you'll see it means to wit. And then to wit has a definition. To wit are words used to call attention to a more particular specification that preceded, and a record which stated that a jury retired to consult their verdict as follows, to wit, the result of their deliberation in them, given with the verdict, arrived at its spread at large upon a record sufficiently identified the verdict. There's been a verdict made by the word viz, by a frickin' jury. The word to wit, that is to say, which is viz, right? Because that's what viz is. These are definitions of what viz is. In a pleading are termed a Vildaset. Well, that's what it is. Viz is a Vildaset. The use of a Vildaset is to avoid a variance. Well, a variance is an agreement we have running with the land, and to avoid a positive averment which must be strictly proved. So again, they're saying that we entered this contract as an infant, of our own free will, right? And they're voidable. Well, this is to avoid a variance, and a variance is like a covenant. It's a covenant that runs with the land. Basically, we gave them legal title, right? That's all we need to do to get back. So this one little word VIZ on this document, leads into pages of stuff that really just starts by going into Bouvier's, to wit. Read what it says. But it says it's a pleading. The statement in a logical or legal and a legal form. So this is their paper. Says it's logical and legal of the facts which constitute the plaintiff's cause of action or the defendant's ground of defense. So whatever this birth document is that has the word viz, right? This is what they're talking about. In a general sense, it is that which either party to a suit a law alleges for himself in a court with respect to subject matter or of the cause. The science of pleading has been designed only to render the facts of each party's case plain and intelligible, and to bring the matter in dispute between them to a judgment. Let's bring it to a head. You say that I agree. Well, here's mine that says that I don't. And then we get into the different things that can happen, which is replevin, avowry, or cognizance. And replevin is a form of a common, what's the name? A common recovery. So pleading, special. By special pleading is meant the allegation of a special or new matter. Well, I would say that that's what they did when they went in and they pleaded their case. Hey, we're bringing in new facts, right? We're alive. Here's the death certificate, which we thought was a certificate of live birth, but apparently it's a death certificate. Okay, I won't go into any more of this. My point is, that's why it's important to look at everything that's on this damn document and know what it is. What is SS? What is a parenthesis sign? Are they using a semicolon? What does the witness box say? In testimony whereof I have hereunto set my hand and affixed the seal of the circuit court. It's a frickin' court order, right? Giving the stuff back to you under two witnesses, done as a deed, because anytime they do it as a witness or in testimony, they're doing it under their oath, under their seal. So in that particular time, they're a conscience before the Creator. They are a man before the Creator, and all men are created equal under the law. So just because it says he's a judge or whatever, it doesn't matter. It's the fact he put his seal. He's doing it as a living man. So